Nadeem, and welcome to this session where we'll be analyzing, if I may say so, path-breaking judgment of the Delhi High Court, where bail was granted finally to student activists Asif Iqbal Tanha, Devangana Kalita, and Natasha Narwal. And to discuss this judgment in detail, we have with us Mr. Colin Gonsalves, sir, and everybody already knows he's a senior advocate in the Supreme Court. He's worked on human rights matters, and he's been fighting for the vulnerable sections of the society for very long now. He's also the founder of the Human Rights Law Network. Thank you for joining us, sir. We are also joined by Ms. Flavia Agnes. Ma'am is a pioneer in women's movement. She has worked on issues of gender and law reforms. She specializes in marriage law and property rights. She's, of course, published numerous articles about the rights of minorities, feminist jurisprudence, legislation against domestic violence, to name a few. We are also joined by Ms. Maithili Vijay, who is a lawyer in the Supreme Court, and she works in cases involving personal liberty and death penalty. And last but not the least, we are joined by Mr. Vakasha Sachdev, who's a journalist with the Quint, and he reports on and analyzes legal developments. He's a graduate of NRSIU Bangalore and is dually qualified and has practiced in firms in London and Bangalore. So thank you all for joining us today. And just to get the ball rolling, may I say that for a lay person, this judgment basically means two things. One is that protest doesn't equate to a terrorist act. And two is that UAPA has been misused, is being misused to suppress dissent. With that, I would like to start with Colin, sir. So what is your say on the political and legal implications of this judgment? So.
Thank you, Rashmi. Good evening, all of you. Thank you, Nadeem, and all my friends and comrades who are
recording in progress
present here today. In a sense, we have come here today to celebrate this awesome judgment of the High Court, which should have come many, many decades ago. But anyway, it's late, but it's very important. And it's the first very clear, very decisive, very articulate, and very simply written judgment of the High Court, which would cover all cases relating to sedition, as well as cases relating to terrorism, because there is a certain commonality in these kind of cases that are filed against people today. And so we have come to celebrate this judgment. We are proud that this judgment has vindicated our stand. It has come late in the sense that hundreds of people have actually been put in jail. And the whole country was terrorized by the idea that if one were to criticize government, that itself is a crime. Strong words against the minister, strong words against the union government, strong words against the political party or a chief minister, those words are enough to put you in jail and to keep you there for a very long time. So the terror came not from civil society, but from the state. The state as terrorists, the police as terrorists. And they terrorized this nation for so long that people, even those who knew the law, began to feel that if they criticized the government, they would land up in jail. Hopefully, no more. I want to say a few words because time is very short. I want to start with sedition, a few words on sedition, because there's a parallel to be drawn between sedition and terrorism. Under English law, mere words were enough. If you said something against the crown, you're having dinner and you made an uncharitable comment on the king or queen, that was enough to hang. Many, many years later, after independence in 1962, in Kedarnath's case, the Supreme Court said, words are not enough. If you say words and there's no action following those words, it's not sedition. You need an overt act, and not just any overt act, not just like throwing stones against the police and things like that, but an overt act of such a scale and of such violence that it was akin to waging war against the state. It was violence meant to overthrow the state. So words, inflammatory words, and action after those words which threatened the stability of the state. That was Kedarnath. But Kedarnath was never followed because the section was not struck down. It was read down. Read down is a way of saying you will take it as if these words that the court is adding, that it must be followed by action. You will read the section as if it says that. But the section doesn't say that. The section said, sedition said, words, signs, visible representations. So when a policeman in the police station opens his IPC and reads the sedition section, he says words. Mere words are enough. And that mistake which Kedarnath made of not striking down the section, but of reading down the section, was not appropriate in criminal law. Because for the policeman, it's not the Supreme Court judgment, but the IPC that he has in front of him, which is his Bible. And I would say, roughly hazard a guess, maybe 500,000 cases. More actually, because in many cases we know, like in Jharkhand, in the against the tribal, 1,000 cases. In one go, 1,000 cases of sedition and so on. And that prevailed for a very, very long time. Now, there are two judgments of the Supreme Court, and I'm just citing them for a very important reason. What kind of words can you use? What is the latitude? And you have Balwant Singh's case. Balwant Singh was a Sikh who believed in Khalistan. And he came out on the streets one day and said, Khalistan Zindabad, we should carve out Khalistan in India, and for that we'll have to mobilize people and get arms and get ready to fight a battle against the Indian state. Fiery words indeed. But when the case came up to the Supreme Court judges said, oh, well and good, he said these words, but did he do anything? And the prosecutor said, no, my lord, he didn't do anything, and he was promptly acquitted. Fiery words. And the second was from Kashmir, a Kashmiri in Andhra Pradesh, who came out and said, we want Azadi from India. And he made some very uncharitable comments about the Indian army. And naturally, he was promptly taken in sedition, convicted, came up to Supreme Court again. Supreme Court said, did he do anything? He didn't do anything. My lord, did nothing at all. And he was acquitted. So even doing something of violence that follows fiery speeches is not just ordinary violence. Somebody throws a stone here, somebody does this, somebody does chakka, jam, band, and so on. No, it's violence which threatens to overthrow the state. And so this is the first point I want to make, that there cannot be terrorism, there cannot be sedition, there cannot be criminality on the basis of mere words. And today we knew it. We all along we knew it. We have a right to say Azadi. We have a right to say freedom. We have a right to say we hate the government. Hatred. Sedition has a phrase. The section has a phrase to bring the government into hatred and disrepute. And we certainly say we hate the government. And we certainly want the government which is disreputable to be brought into further disrepute, but by words, not by violence threatening to overthrow the state. Now, if you look at Natasha's case, I mean, it's so simple and it's so beautifully written. The judge says there's no act of terrorism. He can't find it in the papers. He can't find it in the papers. And I'll take a little digression here. In many of these cases, you'll find charge sheets of 2,000, 3,000 pages. And the police will do solid drama, bringing it in a trolley and, policemen surrounding all the, the documents as they are brought into court, and it will be put on the table. And often, the public prosecutor will say, Your Lordship, this matter can't be argued like this. We can't hear his bail application like this because it requires a lot of hearing. It is better that he goes to trial, which means that you'll spend 7 years before your matter comes to trial. But if the judge was simply to say, as has been done in Natasha's case and now in Akhil Gogoi's case, Mr. Public Prosecutor, the accused says there's no evidence against him, no act of overt violence. So I've got all the time in the world. You have 3,000-page charge sheet. Show me one page from that charge sheet which makes out the charge of terrorism. One page. And I'll deny him bail. But judges don't do that. They listen to the public prosecutor, all the lament about how big it is, how much investigation has taken place, and so on. And he gets misled by all this drama, or he wants to be misled by all this drama and bluffing, and he adjourns and postpones the whole thing. And I'll say one more thing here quickly. You see, I often hear it said in these meetings that the prosecution rate is so low that we're such an ineffective law. That's totally wrong. The fact that the prosecution rate is so low is a sign of the effectiveness of the act. And I'll explain this. If you look at the prosecution rate being low, together with the incarceration rate before the trial, incarceration rate being high, you understand that this act was never meant to prosecute. Nobody's interested in prosecuting. You want to put him in, deny bail, let him rot in jail for 6-7 years, then you're not interested in even coming to the court to lead evidence because you have no evidence. It's the incarceration rate. Deny the person bail, which is the heart of these statutes. All right, so no act of terrorism in Natasha's case. No evidence of incitement to violence. And the judge concludes that the whole charge sheet and proceedings displays an anxiety to suppress dissent. Suppress your words. The CAA protest, no violence. But the mere protest itself was hateful for the government. And you remember in the freedom of speech and expression cases, even words that are bitterly hateful to the government are part of freedom of speech and expression. So my dear friends, the moral of the story is, or the conclusion of this all is, that you can use very strong language against the state. I'm not advising anyone to do this, but I'm saying it's possible, it's legally permissible to use very strong language. Kishore Chandra, our journalist friend from Manipur, got so infuriated by his chief minister in a press conference, I think. He used an expletive against him. He said, FO, FO. And for saying FO, Kishore Chandra was put in jail. And it took 1 year to get him out on bail, to show all these judgments to the court that there's no overt act. He simply said FO. It might be disrespectful, but it's certainly not sedition, and it's certainly not terrorism. The last thing about Natasha's case, where in connection with Asif, I think the judge says, mere use of alarming and hyperbolic verbiage. So very strong language. Mere use of very strong language. You may find it offensive, you may find it hateful, but it's strong language, and strong language alone has nothing to do with terrorism. So this is Natasha's case. I'm speaking very briefly because I have 12 minutes, and I'll go to Akhil Gogoi's case if you don't mind. I want to make the same point with Akhil Gogoi's case, and of course then the other speakers will deal with Natasha's case in much greater detail. Now, if you look at Akhil Gogoi's case, I think the order came yesterday or day before yesterday. You can see the effect of the Natasha judgment already. Supreme Court interfered. Supreme Court had no business to interfere. No business. If the judgment is right, don't touch it. If the judgment is wrong, by all means come in and stay the judgment. But you can't say, oh, well, the public prosecutor can't show me what's wrong with the judgment, but in any case, it's very voluminous, or whatever. You know, if the judgment is correct, you have no business saying it should not be used as a precedent. Why? What's wrong with it? It says I can find no violence. It says I can find no incitement to violence. Therefore, I hold that these people are not covered by the terrorism charge at all. What's wrong with it? Either a court must have the courage to say this is wrong with the judgment, and if it's not wrong, no court has any business interfering with a judgment of this kind. A remarkable judgment, miraculous judgment. Now, look at Akhil Gogoi. I find, this is the court speaking, that though it contains, his speeches contain some sharp political statements and criticism with respect to CAA, there is no incitement to violence. It appears that the tone and tenor of the speech might have been aggressive on the issue of CAA rather than the speech directly inciting violence. Strong words. Akhil used very strong words in criticizing CAA. There was no incitement to violence at all. Consequently, in view of this discussion, I am of the considered finding that the materials are inadequate to attribute any act of terrorism to Akhil Gogoi and to frame charges against him. And so the court in Assam declined to frame charges and discharged him at that stage. And so, my friends, I'll end here by saying it is truly a happy day. It is truly a happy day. And I'm only sad that Devangana, Natasha, and the rest had to spend 300 days in prison. And, you know, thankfully, the judges were very bold and did what they did according to their duty. But to spend 300 days in jail, you know, and when they came out, the way they spoke so calmly, there was some very rabid policemen and ex-commissioner of police on the program where I was there. Without hatred, without anger, without rancor. These are the new freedom fighters of the truly democratic India that has now to be established. It is like a second national movement, a second revolutionary movement, where we want to have India where there is true, genuine, and pervasive democracy. And people like these who went to jail and so many others, like Akhil Gogoi and, you know, Kishore Chandra and all the people who went to jail, and our friends from the Pune case, Sudha Bharadwaj and others who are in jail today. They are inside, but they celebrate with us this victory, a striking blow against state terrorism. Because the biggest terror in India today is not the terrorism from civil society, is not the terrorism from advocates who work in the tribal areas whom you will quickly brand as Naxalites and so on. The real terror in India, and this judgment is a blow against that, the real terror in India is terror from the police and terror from the state. State terrorism is the scourge of this country. Thank you very much.
Thank you, sir. Really strong words from you there, but true anyway. Just picking from what you said, sir, about the Supreme Court actually saying that don't use the High Court judgment as a precedent, but without staying the operation thereof, which is, of course, something that isn't normally done. The next speaker, Metli, would actually elaborate exactly on that, the developments that closely followed the High Court's order. Mehti, will you take over now?
Yes, thank you so much, Rashmi, for inviting me to this panel. It's really great being here. So I just actually wanted to, even though Mr. Gonzalez has done such a fine job in explaining how constrictive this entire legal regimen is, I just thought I'd quickly explain the bail provisions under the UAPA and similar legislations, which then I think will make the points that I have to say about the Supreme Court, to put them in context. So, so we all know that bail under the UAPA or in similar legislations is practically impossible to get because that's how the legislation is designed. They don't want you to get bail. The normal rule of bail and not jail is flipped in the words of the statute itself, right? So 43D5 says that you have to prove, or unless the judge sees that there's no prima facie proof against the people who are accused, they have to give them bail. It's very hard for a judge before the trial has started, only on the basis of a prosecution case, to then say, oh, there's actually no case. Because then what you're essentially doing is trashing the prosecution's case entirely. And that is highly unlikely to happen at that very stage. Now, then what happens is the Watali judgment comes in and further binds the hands of the defendants, saying that you have to take the prosecution's case at its word, and you can only dispute or you can only make your case from what the prosecution has said. So basically, I'll just give you an example. It might sound frivolous. So let's say Natasha is accused of something. And let's say at that relevant moment, Natasha is in New York. She can't say, but I was in New York and I wasn't physically present here to do this, because that would then be leading defense evidence. That is the only thing that she can do is point to something in the case diary or an investigative report to then say, okay, here's something to show that I'm not in Delhi, therefore please give me bail. The reason
Recording in progress.
Since December of 2019. This was obviously, this is obviously widespread. This is obviously undeniable. So the things that they have accused him of doing is that there were various activities used to orchestrate the protests against the CAA, that the object was to organize a chakka jam, right? Like to block traffic and therefore to basically spread fear and anarchy. To say that they were using like a WhatsApp group to sort of coordinate between them as to what they were supposed to do, to meet different people in different areas, to say, do this, do that. That they were part of something called like Jamia Fear and Anarchy, which I think was the name of the WhatsApp group, and they were coordinating. They were using like a WhatsApp group to sort of coordinate between them as to what they were supposed to do. That there was intention to sort of visit particular, that they were part of something areas where a specific community resided, and to sort of rile them up or to meet the local leaders. That they passed around SIM cards that were a part of that WhatsApp group. So these are broadly the allegations that were laid out. So these are the facts that we have to deal with, because this is what's coming from the charge sheet. Now, under the UAPA, they have been charged under 50, which is basically like the Offense of a Terrorist Act. Then there's section 17, where you raise funds and you raise support or whatever for the Terrorist Act. And then there's 18, which is conspiracy. So basically, even if you're sort of one part of a terrorist act and haven't done the act yourself, you can be punished under section 18. Now, the interesting thing that Justice Bhambani does, so now it's the other thing that I want to point out is that the UAPA is an old legislation, I think enacted in the 1960s, if I'm not mistaken. It wasn't originally intended to deal with terrorist acts. That was a later amendment that came about in 2004 and then in 2008. So now Justice Bambani makes this very sharp point. He says the point of the UAPA, which has of course been enacted by the center, is not to deal with everyday law and order problems, because that is not the job of the center. That is in fact the job of the state. So what the center can deal with are terrorist acts, offenses that threaten the defense of India and the unity of India. That is what the center and these acts then have the power to punish. So if it is everyday, like bread and butter crime or like ordinary activities that sort of disrupt law and order, that is not something that a terrorist legislation should certainly be looking into. So that is a point that he makes with the UAPA. Secondly, Justice Bambani lays down the contours of what he says Section 15 now. So Section 15 is a very broadly defined section and defines various acts as terrorist acts. It's fairly exhaustively defined. What Justice Bambani does is to say that even if it is widely worded, according to the principles of criminal and constitutional law, any criminal provision that is broadly worded is an antithesis to the spirit of the Constitution, right? Like you cannot have vaguely worded provisions which then take away so much liberty from a person. The definition has to be precise, and so does the act under which that person, the act for which that person is arrested under this provision. It cannot just be like a catch-all provision to then sort of include whatever the prosecution or the police feels like. And this is certainly not jurisprudence that's pulled out of thin air. This is something that the Supreme Court has been repeating for over, I think, a period of 5 decades. Justice Bambani reiterates this and says that the way that Section 15 has to be read is that it must partake the essential character of terrorism. Now, what he does is he looks at, older statutes. We've had like TADA and POTA and a lot of things which dealt with terrorist offenses. And he goes into various cases to say, listen, a terrorist act is not just any act, right? Like it's not just, obviously, look, if you're going to go and stab a person, obviously he's going to feel scared and that's a crime. But it doesn't necessarily disturb society. The point of a terrorist act is that it is supposed to shake, it's supposed to psychologically and mentally shake not just you, but society, people around you. It is supposed to, let's say when you target public officials or when you cause widespread damage, or when there is a clear intent basically to make sure that law and order falls apart. A terrorist act is not something that you use casually and lightly. It is a very serious offense, and it has been interpreted and defined by enough judgments over the years. Now, Justice Bambani makes this point where he says, firstly, that Section 15 is too broadly defined and it must only apply to offenses that partake the essential character of terrorist offenses. The second thing that he wants is that if you're going to apply UAPA to sort of any sort of frivolous offenses, like bus ko tod diya, ya, window ko tod diya, this, that, and the other, then you're basically taking away the character of the UAPA. If you're going to use it frivolously, then what is the point of penal law, right? Like the point of stricter acts is not that you apply to regular crimes. It is you are basically using it because you are saying regular penal law is not enough to deal with this breakdown of the law and order situation. There is something extraordinary that's happened here. It is very severe. It shatters the foundation of democracy, whatever you want to call it. And therefore, we need an extra strict legislation to deal with this. You cannot keep invoking UAPA at every small instance. Now, I might be mistaken, but you see, there aren't very many judgments interpreting the provisions of the UAPA. And I think this might be the first, which of course not just interprets Section 15 in this light, but also reads it so narrowly. So this is where Justice Bambani has dealt with the interpretation of terrorist acts, right? And now when it comes to the facts, he has found, so I've focused on Asif's judgment, which is the primary judgment. He has basically said, look, and the thing that applies to the definition of terrorist act also applies to how a section applies. If you're accusing someone of being a terrorist, they would have had to do something to warrant that act applying to them, right? Like you can't just say, look, there was riots happened on the 22nd. At some point, these people were on a WhatsApp group on the 20th, and therefore at some point this becomes a terrorist act. No, a terrorist act has a specific definition. You have to attribute a specific act done to them. There has to be something, either they have arms on them, or at their instance, you have discovered arms and ammunition. There's some kind of conspiracy. There's some kind of evidence. There is only one piece of evidence that the prosecution themselves, and no defense witness, no defense evidence, the defense has not put forward their case. From what the prosecution has said, the only role that they have attributed to Asif is that he passed on a SIM card that belonged to someone else to one of his co-accused, which was then used to be a part of that WhatsApp group. That is the only role that has been attributed to any of these people. Secondly, the courts have said, the state has said that these people were a part of course, the Jamia coordination group, which they're calling the JCC, and that Asif was a member of the student SIO. And neither of these are banned organizations. They're just, all Justice Bambani, in fact, Riley said, he said that all that this JCC seems to be is a WhatsApp group. It's not even like an organization, forget banned under anything, right? So these are not banned organizations. The state has done nothing to ban them or prevent them. All that they have found, the evidence that the state has found against Asif is that he passed on a SIM card to someone that was then used in a WhatsApp group. None of this falls either under Section 15, which is a terrorist act, or for 17, which is raising funds, or 18, which is committing a conspiracy. Like on the facts of it, they have not been able to make out a case. Now, the other thing that now when it comes to now, the court has now dealt with the individual roles of these people. The other thing that the court has said, sort of, very much sort of extrapolating from what they had said about the nature of a terrorist act and what its impact has to be. They said that, look, just protests and just raising your point of view, whatever it might be, does not threaten the foundation of a democracy. Whether you like it or not is completely different. But that does not make out the ingredients of an offense under a provision like the UAPA. And look, if they have, if there was damage to public property, because there's an act under which they have been charged as well. If there's damage to public property, if there was nuisance created or whatever, the ordinary law will take care of it. And these guys have been charged, and I think have also received bail under that. What is so terrorist about this, right? Like, because what the state was trying to say was that these weren't ordinary protests, something larger was afoot. But the state says, look, if there is something larger afoot, you have to show it to me. You not only have to show it to me, you also have to show me what these people were doing in aid of that larger conspiracy. You can't just say there was this larger conspiracy and then these people had some role to play because they were in a WhatsApp group and then something happened and the riots happened and therefore they are now being charged under these sections. You can't just say that. You have to show that they had a particular individual role, right? You have to show that there was a terrorist act committed. Only then can you apply this act. When it comes to the right to protest, again, I don't want to say too much. Also because there were no other facts and clearly no evidence there, obviously, because this is bail at a very initial stage. But what Justice Bambani has done is basically to reiterate the right to protest under 19(1)(b), which has been again long recognized by the Supreme Court, more so in the MKSS case, and when it then said your legitimate right to protest is distinguishable right under the Constitution, because and that cannot be taken away. There was just a reiteration of that. I just wanted to end by making and the judges also said that so far there has been no evidence that the protests then crossed over into being violent, which would be a law and order problem at the IPC, or have then further crossed over into being a terrorist act under a UAPA. Right? The state has not been able to show either through their charge sheet or through their evidence that has happened. I just want to end by saying I know that the Supreme Court's order staying the observations has brought on a lot of furor, and I just wanted to explain that a little more. So basically what has happened is, as I said before, there aren't very many judgments in the UAPA. This is the first time I think that Section 15 has been interpreted, and certainly in a narrow light. It would be very unusual for the Supreme Court to not go into it further, right? Because this is about the interpretation of a particular provision of law. The Supreme Court is sort of bound to take notice of that. So it's not, they haven't stayed the bail. They certainly haven't told them to go back. They certainly haven't told them to go back to jail. And I think it might be at this stage, premature to perhaps criticize the role of the Supreme Court. I think more can be said once the hearing takes place and to see what they say further, because at this stage, they've only stayed the observations and issued notice. So it's honestly too soon to say anything. The second thing actually that I wanted to address was, I'm sorry, I'm forgetting anything. Right. Sorry, I think the second thing that I wanted to touch was because you wanted to know if this would have any impact on other political prisoners that are there. So the thing is, when it comes to the staying of the interpretation, because what Justice Bambani has basically done is to narrow the definition of a terrorist offense. And obviously, if the judgment was or if those observations had not been stayed, then it would have been much easier for a lot of other people, let's say, who had been caught under the very broad language of this act to get bail easier, but it certainly does not prevent anybody from getting bail because as we can see in this case, because there was no precedent for this, if they have a strong enough case on merits, then they're perfectly entitled to get bail. Yeah, that's about, I think that's about it, unless there's something else, Rashmi.
I think you've covered all bases, Maitri. Thank you. Actually, just deviating now from the facts of the case and just concentrating on the gender issue involved here. Natasha, Devangana both spent more than 300 days in prison, as was rightly pointed out by Colin sir. I would request Flavia ma'am to just elaborate on this. I mean, do you think that gender plays a significant role, ma'am, when it comes to bails or criminal trial in general? I mean, just a brief analysis by you, ma'am.
Thank you, Rashmi, for inviting me on this panel. Frankly, I must admit that I have not read the judgment in detail in this particular case, nor have I handled many cases under the UAPA. So I'm not familiar with the entire discourse. What I am familiar with is the entire gender discourse and how it plays out. Now, if you see in Bhima Koregaon case as well, there are 2 or 3 women there, SADAA Bharadwaj, Shoma Sen, and from Kabir Kalam, and young girls are also arrested under this. And none of them have been able to get bail, unfortunately. Despite Sudha's deteriorating health conditions, there are many things there. The only 2 people there who have been able to get bail is on humanitarian grounds due to their age, Varavara Rao and Stan Swami. And also their deteriorating health conditions. They have serious health issues in the prison that developed, etc. SADAA Bharadwaj had approached the court for bail for herself and for others. So has Shoma Sen approached for bail for herself and others. And they are also facing terrible situation, again, due to their age, due to their physical conditions, etc. But court has not considered this. Now, here what we see in this particular case, in the bail order of Natasha, it is not just on humanitarian ground. I mean, there are also other people who got bail, who was pregnant, Safura Zargan, and then Devangana and Natasha comes in one bracket. Again, here the pregnancy, that she was pregnant and was in jail, was in custody, and where the prosecution had argued that we have had more than 100 deliveries in jails. So what's wrong with jails? Pregnancy is a natural condition. It's not a special humanitarian or health condition. So they have not given any leeway for the gender-related issues of those arrested under UAPA. So what comes here, what I am very happy about, is this whole movement, Pinjra Tod, which started in a much earlier context of the curfew orders within universities and colleges and hostels, etc. A strong patriarchal control on women's movement, women's sexualities, women's freedom. And they became the initiators, or they became the inspirators for the several protests that followed later. And I am so grateful for them to bring out this issue, which some of us had brought up much earlier, maybe like 2 or 3 decades ago, in Mumbai, in other places, about train travel, and that women going out in the night, about the bar dancer issue. Several of these issues had this particular concern about quarantining women and not letting them out after a certain time frame, so that in order to protect them against what, and protect them for what reason? None of this was specified, but it was understood. It is a code language. It is followed by everybody, that women should not be out. Underlying thought is that they should not be raped, they should not be safe, etc. Nobody is saying men should be quarantined and women should go get free and go out at night. So this whole movement of reclaiming the night was there in several places. in India, in other places as well, midnight marches, etc. So I'm so happy that these young women are carrying forward that legacy of strengthening women's spaces or expanding women's spaces and bringing the gender concerns over there. So there, I feel not only these young women, but also much older women in the CAA protests, but particularly at Shaheen Bagh, etc. A lot of women came out, and a lot of women took a political stand. Majlis had made a film on the Bombay riots way back in 1994. It was awarded the Filmfare Award. And here, and the title of the film is I Live in Berrampada. And many people used to ask us, do you live in Berrampada? And what we are trying to say through that film is, it is the women who live in Berrampada saying that I live in Berrampada. This is my space. And how dare you badnaam this space and make us out to be terrorists. So in that context, this film starts with a women's voice, continues with a women's voice, and ends with a women's voice. And these are all very ordinary women, just expressing their concern about their daily life issues, what's happening to their family income, what's happening to their children's education, how difficult it is to go out of Berrampada into the so-called mainstream society because they are targeted, their children are targeted. And this was of extreme concern to us, because usually when you make film, particularly on political issues like riot issues, etc., you talk to the men of the community. And then the women's voices are added on just to give certain legitimacy. The entire film doesn't speak through the women. And here we found that entire film speaks not only through the women, but their extreme articulation about their rights, their awareness about their rights. So, and that was a big contribution to the movement at the time on the issues of Muslim women and how they assert themselves in the political sphere, rather than the women are oppressed and they don't have space, etc. And we found that men much less articulate than the women. And when I see the Shaheen Bagh protests and the women over there so articulately expressing their concern why they are protesting, it always brings back memories of our making of this film, I Live in Berrampada, and the way they carried it on and the way the whole myth was shattered that terrorists live in Berrampada and the bombs are being made in Berrampada. This was the myth that was created by right-wing Shiv Sena at that time, as well as by the police and the mainstream media. And this film was a huge contribution to demolish that myth. So, I mean, now we are like 3 decades on and we're still dealing with the same issue. And that's a sad point. But the protests are coming from young women who are so strongly protesting, who have been arrested under this draconian law, who have spent so many days in jail. Natasha lost her father. He couldn't meet her before his death. There's so many very moving, very heart-rending incidents that have happened. But the women have carried out. And that brings us a lot of hope for the future. Because somewhere within the women's movement, there's a feeling that what next? I mean, what have we gained? Where have we reached? And here comes a new wave, a new young blood taking on the same issues forward. For me, that's the most inspiring part of this. Now there are here young pregnancies are there, the death in the family are there, so many other concerns which affect women much more than they affect men, because women are so integrally rooted within the concerns of the family. They are the caretakers, they are the life givers, etc. And taking on all these different roles, they have taken on this role and paid the price and have been incarcerated for such a long time. And I'm so happy that it is not come as a concession to gender. It tackle the whole mainstream politics and in a way the judgment tears apart the premise of UAPA that any ordinary act of protest is a terrorist act. And that's the biggest breakthrough that we have got, which Colin mentioned, And Michael, you also mentioned that the breakthrough here is that through their struggle, through this judgment, they have narrowed down the scope of UAPA, and henceforth arrest cannot be so randomly made. They have to be much more specific. Take the offense beyond law and order question to an act of terrorism, to an act of safety of the entire state. And where the judge has very clearly stated that any act of protest is not a terrorist activity, any breakdown of law and order is not a terrorist activity. Terrorist activity has to be something beyond this. So when you are looking at this issue from the larger political perspective, you clearly hear a woman's voice here, clearly hear women's protests here, right from the issue of greater freedom to universities, to the CAA protests, reclaiming the streets, to expanding the scope of granting bail and narrowing the scope of the UAPA arrest. So as Colin rightly pointed out, this judgment should have come a long time ago, but it is far too late. But yet I feel that it has come now, and it is a trailblazer for all the future arrests that the state is going to make. And I hope there will be many judgments like this following this Delhi High Court judgment. The Supreme Court has said that it cannot be used as a precedent, etc. There will be a lot more people now filing for bail and referring to this judgment. And I'm so glad. I mean, there are many people there. There's a lot of men and women, youth in this, but women have played an equal role. They have played an equal role in the nationalist movement. They have played an equal role in the anti-price rise and other civil society issues later. And in the feminist movement, you can see many voices, very strong, very clear, protesting against various kinds of patriarchal subversions that are going on and expanding the scope. So while the space gets constrained in decade after decade, there are also protests against it to expand the scope and relying on the earlier movements where women have played an important role, taking this issue further, taking it, strengthening the space for women within political protest. That is, I think, is most important, and that is what I really congratulate the young women of JNU and in other places and in Shaheen Bagh to take the protest further on the political platform, on the political agenda. The patriarchy that we are confronted all the time at home, in a way, expands to the public domain, and all the public officials are functioning through this patriarchal framework. And we need to challenge this all the time. The more we challenge, the more we are pushed back. But somewhere, I think we have made a progress. Last 40 years have been very important protests everywhere in India that have gone on. And I'm glad that issues come back to Delhi and is now placed very squarely there. And its repercussions will be felt all over India. So these are the words I want to say, not specifically on this judgment, but overall, broadly, what this judgment means to all of us who have been in this movement against patriarchy.
Thank you, ma'am. Actually, just to add to your observation of the Shaheen Bagh movement, ma'am, I know of ladies who used to manage their house time in a way that they could go and sit in the protests. A lot of stories like that from Shaheen Bagh protests. But picking on one thing that you said, ma'am, that the myths that got associated with the ladies about whom you made the film, the riot film, and how prejudice and myth sort of surrounds a community. Unfortunately, we also witnessed it after the Shaheen Bagh protest, how it was pinned down to one community. And now I would request Mr. Vakasha to just elaborate on that, and how this judgment sort of exonerates this one community from being labeled as, you know, a terrorist organization, and how it's legitimate for every community to protest for their own interest, to protect their freedoms and fundamental rights. Mr. Vakasha, you there? I think you're still muted, sorry.
Yeah, okay. Can everyone hear me at this point?
Yes, yes.
So there's two things which I'm going to sort of cover in my segment in this. I'm going to be talking about two aspects. One, as Rashmi's pointed out, is going to be the issue of the right to protest and sort of what the court's observations mean for that. And the other thing which I want to deal with, and I think which is very, very important, is about misinterpretation of this judgment and the way it can become, and I mean, we've seen this already happen with the way the Supreme Court has dealt with it, the way it can actually now become sort of the way misinterpretation can therefore affect not just this judgment, but other cases as well. So to begin with, I think the issue of the right to protest is very, very succinctly dealt with in this judgment, because what we see is not a sort of just set of random platitudes which sometimes come up in judgments about the right to protest. There's no random comments just about, oh, you know, we have this great tradition of free. We've seen, I mean, we've all remember that we've seen judgments where there'll be talk about, oh, India has a grand tradition of protest dating back to Vedic times, etc., etc., etc. That's none of that really actually ends up changing the discourse around protests or ensuring that there is a legal framework within which protests are examined and looked at. That is where this judgment actually really goes quite far, because what it does is it conducts a very good analysis of previous cases and their statements about the right to protest. So, you know, for example, it looks at Himmat Lal Shah and talks about how what is clearly said is that, you know, that you can't just ban protests in all sort of areas. It even picks up on the sort of international legal obligation of the right to facilitate the, you know, the obligation of the state to facilitate protests. But perhaps the most important aspect of the right to protest which it looks at is in the context of the Mazdoor Kisan Sangathan judgment from a few years ago. Now, within that judgment, one of the key points which the court made there is that it doesn't matter whether the protesters are right or wrong, or whether you consider them, or whether people consider what the protesters are saying is justified or not. And this is very, very important, especially for community-based protests. Now, with the CAA, one of the classic arguments being used against the people who are protesting, and it's essentially against the Muslim community, is like, oh, you're saying that this is against you and you're making all these things, but actually it's not against you. It's got nothing to do with citizens of India. The constant rhetoric you hear, whether it's from you know, people who are defending it, civil society people, who the very few who actually are trying to defend that CAA, or from the government or from the police. And we saw this particularly, that, you know, you had police officers going up to protest sites and continuously telling protesters, oh, what you're doing is wrong. There's no such issue for you to be concerned about. And that's then reflected a lot in the way society treats these cases, is that people have been trying to, there's been an attempt to kind of make sure that this entire idea of the CAA protest is considered misguided. And once it's considered misguided, then you can therefore crack down on it regardless of, you know, what steps are taken, whether those steps are entirely legal. What the court has reaffirmed, I believe, in the right to protest, which is the most important here, is that it does not matter. And they've cited, and again, this is not just, you know, the judges of the Delhi High Court applying their own interpretation, which they're entitled to do as a constitutional court, but they've located that within a Supreme Court judgment and its provisions to make that point very clear. Now, this is particularly important, I think, when we're dealing with the arguments about the CAA, with the cases out of it as well, because the Delhi police have tried to argue that the fact that there is no basis for according to them, that there is no basis for the protest, is therefore proof also that the entire CAA movement protests were part of a conspiracy to attack the government. So if you see the charge sheet, you see the way they've framed the segment where they've discussed the organization of protests, particularly around Donald Trump's time. You know, I mean, they've tried to make this argument that there is no merit to this, and that everybody knew there is no merit to it, and therefore the fact that these protests were being organized is itself proof of a conspiracy to escalate the protests into something more. Now, what the High Court has done here is they've pointed out that that is not something you can, whether or not it may turn out to be that these protesters have got it completely wrong, but that is irrelevant. And this is a powerful thing for protesters across the board. It's something which is which validates, you know, it's not about validating the specific argument, but it's about validating the right to protest of the farmers protest, because, you know, you have many people saying that, oh, the farmers protest, what they're saying is, you know, that they're overblowing the situation. All of those things can be argued, but they still have that right to make that argument. They have that, and their right to protest is as legitimate as anyone who has mass support behind their position. So that is the most powerful point here, that what you got to look at is not whether or not the cause of the protest is valid or not. What you look at the end of the day is purely going to be, where did the protest go? Now, even within that, they've talked about the fact that when tensions are high, when there is a whole certain, there will be inflammatory speeches. There will be points when they will argue things which you will not like. But again, that doesn't necessarily make it stray from being a lawful protest to an unlawful protest. Once you've even reached a threshold where it's no longer a lawful protest, where they've breached violations which are actually, they've breached restrictions which are reasonable, even then it doesn't, just because there's a certain aspect of criminality, it doesn't become a conspiracy to conduct terrorism. So what's important to understand here is that the court has not necessarily said that what the Delhi police are saying is incorrect. And I think this is where it ties into my point on misinterpretation and misinformation around the judgment. What the court has said is, the court has been very careful, and this is what particularly has to be appreciated about what the court has done. They've been very careful to stick within the bounds of the text of the UAPA and of even the constrictions which were placed around what the court can do under Watali. They have said that the allegations, and you can see they've in fact, many times I italicized this to, I think, emphasize this point, is that they've not looked at the evidence. They've not tried to make an assessment on the basis of, oh, the Delhi police were brought, we've all seen, those of us who've seen the charge sheet, those of us who've seen the allegations, there's a law which is rather ridiculous. There's claims which are made which don't make any sense. The whole way in which you got just all these, protected witnesses, 161 statements, all of this kind of thing, we may all find is suspicious and problematic, but the court does not delve into that. What they've said is, and they've emphasized this consistently, what are the allegations by the police, and the allegations against these three specific people. Each order is specific to them. It is not making a statement on the grander claims of conspiracy, even though one may like it to. And this is where I believe it's also been these judgments have been misinterpreted by even people who are anti-CAA, people who are supporting the protesters. And the fact that they misinterpreted it is also is in fact a disservice to them as well, and disservice to everyone who's being charged with the UAPA in this abusive fashion. Because what you see when you see the grounds for urgency and the grounds for appeal which the Delhi police have filed in the Supreme Court is actually building on this. They're upset over the fact that people are reading this judgment as this massive attack on the Delhi police's case. And obviously that's going to upset them because it's a big slap in the face. But what the court has done is they've been careful. They've not gone on this wide sweeping exercise, which is going to then create a problem, which could potentially invite intervention by the Supreme Court, which could then, where action by the Delhi police could even be justified. The court has restricted itself to the points, to the allegations against these three people. Now, why is it important that this is there? And some people may point to that paragraph where they say, oh, we are constrained to find that there is an attempt to suppress dissent by using terrorism, and say that therefore this is an attack on the Delhi police's claims of conspiracy as a whole. No, it's not. It is saying that in the context of the allegations against Natasha. And you can see the distinction because there's a point in both Devangana and Natasha's orders where they pointed out that all that is said is that they've done stuff in relation to the main co-accused, and that when the main co-accused are supposed to be giving directions, there is no mention that even these directions were made to Natasha or Devangana. This is important. This is vitally important for all of us who are going to be talking about this judgment to also understand that, because otherwise we are doing a disservice to the Delhi High Court by taking it beyond that. The principles that the Delhi High Court has laid down are vital, and they're important for us to look at. And we have to crystallize those. So I think one of the best examples of this is the way Gautam Bhatia has described it on his blog. He has crystallized at the end the key points made by the Delhi High Court. And you can see very clearly that he's pointed out how the courts arrived at its interpretation, how it's arrived, and what that interpretation can be used for. But you can't say that this judgment is itself going to be grounds for it. Now, the reason why I'm bringing this up in the context of people who are even supporting it is because there are people who are getting it wrong. Even people like Pratap Bhanu Mehta, who's written a otherwise very excellent editorial in the Indian Express talking about how this may be an opening of the black box of the UAPA. But then he's also made the mistake of saying that the court has looked at the evidence. There's a point where he said that the Delhi High Court has looked at the evidence and said that evidentiary considerations can be important to this. No, it's not, because the Delhi High Court does not do that. I'm reminding everyone again, when you look at the provisions of the look at the text of the judgment. They've specified that they're only looking at the allegations by the Delhi police against these 3 people. Now, why does this? So the danger, however, is that when you have even people who are in favor of this misinterpreting it, obviously the Delhi police are going to misinterpret the judgment. Obviously, Tushar Mehta is going to go and make statements. Now, we look at one of the things they argue. The 2 key things they argued in the Supreme Court was that there is a watering down of the UAPA. They've argued that the court has done its own interpretation of Section 15, and that the way the court has interpreted said that Section 15 has to be looked at in the concept of terrorist activities, has to be looked at in the context of defense of India and sovereignty and integrity of India. They've said that is beyond the scope of what the court could have done here because there was no challenge against the UAPA, and that this was, the court's own interpretation, which is incorrect and opens the floodgates. So 2 key points. One is that the court has watered down UAPA, and 2, that there is that the Delhi High Court is trying to create some interpretation of restricting the UAPA. Both these counts are factually, it's manifestly incorrect. The tragedy is because you've had this level of misinterpretation by everyone, including those in favor of the judgment, is what then also leads to the Supreme Court judges, who should be knowing better, but accepting this argument. Like when they were saying that, yes, we are going to issue notice, they made the point that, yes, we agree with you that there seems to be a watering down of the UAPA, which is absolutely ridiculous when you look at the terms of the Delhi High Court orders. What do the Delhi High Court orders say about Section 15 and all these others? It is not actually saying that we are changing the interpretation. They've looked at a previous 2010 Supreme Court judgment. So the entire analysis which the Delhi police have got upset with, and they've quoted a segment, paragraph 57 from, I think it's Devangana's, or is it from one of the judges? There's a paragraph 57 which deals with this whole concept of, the UAPA dealing with defense of India and integrity of India. They've quoted this whole paragraph in their grounds for challenging the order. This entire, the entire interpretation applied by the Delhi High Court is taken from a former Supreme Court judgment. And yet they're trying to claim that this is the Delhi High Court misinterpreting the UAPA and creating a new interpretation of the UAPA, which is manifestly untrue. The other point is about watering down the UAPA. That's that their interpretation of Section 15 waters it down. No, it does not. Again, the way the court has looked at Section 15 is again just a way of making sure that we actually think about the way we're using these legislations. It's not about saying that, we're creating a new jurisprudence around it. It's what the jurisprudence has always been. There has been a misuse of these provisions by the police. There's been a misuse of these provisions by governments, by the courts as well, who have failed to conduct the basic assessment required. What the court has done here is not new. And that's the dangerous part, because what you're seeing is the Supreme Court accepting without any basis this argument that what is being done here is new. And it is therefore hoped that when we actually see arguments in the Supreme Court on this in July, it will be pointed out that all these issues which the Delhi police is taking with, that the Solicitor General is taking with this case, these are things which are derived directly from Supreme Court judgments of the past. They're not new things. And I think that leads us back to the point that what the Delhi High Court is doing here is not new. It has applied principles which have been in place in Supreme Court judgments for a long time. But unfortunately, most of these Supreme Court judgments, as we talked about, they say a lot of things, there's random platitudes, and then we just move on, and the courts pretend that everything is okay at the lower level. But as Colin has pointed out, it is not, because especially at the lower level, you see this vast machinery of the state used to create and tag on, offenses against people under serious legislation, under serious offenses, which aren't actually made up of what the process is itself, the punishment. So what we have to look at is that the Supreme Court interference could now become a problem with that, but it doesn't actually in itself stop people from applying the same approach which the Delhi High Court has done. And I think that's something to emphasize going forward, is that the key thing about the Delhi High Court judgments is not necessarily saying that, we want to therefore cite state versus Devangana and Natasha versus the state, etc., and therefore get paid. It's about saying that the way we approach interpretation of these provisions, the way we approach these cases, that approach can be used even without citing these judgments. And that approach is a purely logical one, saying that the police have to be able to, on the basis of their bald assertions, they have to be able to make out a case. Otherwise, the next thing and the danger of this kind of thing is, and we see this already, is that there's a cheapening and a dilution of when people are being attacked with, are being charged with offenses. The next thing we're going to know is that someone says that, a Facebook post saying Modi is not a good prime minister, police say so. That This is where the court has to look at the assertion, right? They have to look at the allegation and say, does the allegation have anything to do with it? The evidence is irrelevant here. And that's something which, as I said, it's dangerous, therefore, that we have even people like Pratap Bhanu Mehta and others who are writing in support of this, making the mistake of misinterpreting the Delhi High Court judgment. So I think this is a great, the fact that there is this conversation today is, I think, really important, because it's important for us all to understand how to talk about the Delhi High Court judgment as well, even those of us who find that it is a good one. We have to emphasize that it is about approach. It's not about reinterpretation. It's not about trying to change the way things are done. This is merely a matter of saying this is exactly the approach which should have been followed in UAPA cases from the start. I think once again, just to sort of return to the issue on the right to protest, I think what we have to remember is that there are, of course, going to be cases where the right to protest will also lead to potentially, will lead to not just criminal activities, but potentially also give rise to terrorist offenses. That can happen. What has to be done is, what we have to have a look at is ensuring that we have a sense of rigor and critique around the way this is done, that it doesn't allow the courts to, doesn't allow the police to misuse this just in every case. And that's why these, the Supreme Court case, and this is going to turn out to be something very, very vital going ahead. Because we have to understand that there are going to be, there's constantly going to be pushback from the state against this, against the idea of protest. What we have to make sure is that, there is an understanding within civil society that this is not just, that the right to protest has to be there even where you don't agree with it. One of our fundamental problems in India as of now is that there is an acceptance of this abuse of police power. There's an acceptance of putting people in jail without trial, putting people and most importantly, there's an acceptance that when people protest, they are terrorists. When people say something which we don't like, that's a criminal offense. It's almost a cheapening of the idea of personal liberty, which has gone on for a long time. And unfortunately, it's not been checked in civil society. There have been lawyers who fought for this. There have been people who, however, unfortunately, then been derided as, liberals and, bleeding hearts who, don't care about this. But the problem is that discourse in civil society needs to change before we really see the benefits of this kind of judgment coming through, because there has to be an understanding that even if I disagree with you, even if I don't like what you're saying, that still doesn't mean you should end up in jail. And it's a very simple point which all of us, especially maybe who are on this call, may think is absolutely normal and an absolute basic and a given. But actually, unfortunately, throughout our society, that is not a position which is a given. So while we are celebrating this verdict and while we're looking, while the lawyers will be looking at how to get these arguments used in similar cases, we as who are, sort of also involved with public outreach and civil society measures need to be looking at how we can start changing those ideas which allow this kind of misuse then to become so rampant, because it has happened. And I don't want to say, but it's been the fault of previous generations which have not argued against this enough as a society. So we need to talk about that as well, that, how do we try to disseminate the message behind this judgment, not in terms of the judgment itself, but in terms of the values it is giving about ensuring that we don't just accept what the state is saying, and that we also give proper value to the right to protest, even when we disagree with someone else.
Thank you, Akash. That was an excellent and much needed interpretation of this judgment, I think. And I also feel that the Supreme Court has sort of left it open in a way for you to, now support this interpretation of the judgment. But I think Maitli wanted to add a point to this. Maitli, you can just add it.
Hi, yeah, as Vakasha was speaking, really excellent talk, by the way. There's something just struck me because, like a lot of the criticism about the Delhi High Court judgment was, this is a bail order. If it's going to go on for 100 pages, of course, the Supreme Court is going to issue notice. Apart from that, the thing is, you see in UAPA when you have the Vatali judgment, when the judge can't look at evidence, when the defense is not allowed to raise arguments or even file written submissions, the only thing that the judge can do is to interpret the law. And that is it's what you're supposed to do anyway, but I suppose it is more important here, especially when there has not been a judgment on Section 15, right? And because Section 15 has begun dealing with terrorist offenses only as recently as 14, 15 years ago, in terms of ages of legislation, that's a very small thing. So the judge can't look at evidence. The judge can't ask Natasha, Devangana, Asif what they've been doing. What the judge can do is say, okay, I'm going to look at the charge sheet. Now I'm going to look at what terror means, because this has been going on for the past 40 years. What has the Supreme Court said? And then see if this applies to that. And and they have stuck to their brief so excellently, right? And in the way that Bakasha said, sort of like reiterating that you cannot criminalize and certainly not use a terrorist offense to criminalize the right to protest. But even the way that the judgment has been structured and dealt with, they have only dealt with the law and the charge sheet. And therefore, I think, as Bakasha said, more important to emphasize that. The judges had no choice but to only focus on the interpretation of the law. They had nothing else in front of them they could look at. And that was obviously enough on the facts of this case.
Thank you, Maitri. Can we just have a quick interaction now? We can take some questions up if anybody has any question for the speakers.
Yeah, I would like to ask one question. Like, I'll try to keep it very crisp. In the light of Section 19A, like, how do we, how do we see this right to protest thing? And though it is not mentioned in the in there actually, like the protest word is not mentioned there, but still this judgment, if we have to see like from the view of 19A, and like if we can take this further for the other guys who are still in the prison to get them out. That was just one question.
Is your question addressed to anyone in particular?
I mean, anybody would like to answer that. I just would like to listen the feedback on that.
So please, anyone.
Yeah.
I mean, if one can, I mean, I think Colin would also maybe have something to say on this as well. But I just like to very briefly point out that the 19(1)A issues are specifically dealt with in the judgment. As I was talking about, there is a clear explanation of an examination of the right to protest within this. Now, what we have to understand again is that it must not be said that these observations within this can directly apply immediately to other co-accused. There is a point in these judgments where there is a delineation between the accused, such as the accused here, which are Natasha, Asif, and Devangana, and the main accused in the case. Now, as you know, the main accused in this case are Umar, Khalid, Sharji, Imam. What you have to understand is that it's not about saying that these points made about the right to protest will directly mean that they will get bail. And that is not something which they are going to end up doing either, I'd imagine, because it's clear that the judgment is not going to apply to them. But it's again about the approach, and it's going to be therefore that when we're looking at the allegations against Umar and Sharjil and the others who are the main accused as well, when they are being, when the allegations against them are coming up, again, the police are going to have to be able to have something more than just saying, oh, they organized a chakka jam, therefore they're organizing a conspiracy for terrorism. That's almost at the heart of this, that the police seem to think that, oh, we can show that these guys have, our whole allegation, these guys are planning to organize a chakka jam. Therefore, that is equivalent to organizing terrorist offense. Now, with Sharjil and Umar, there is more. For instance, with him, with them, with Tahir Hussain. Whether the merits or demerits of those allegations is not the point, but there is at least on the face, at least the police allegations, there are more. So it will, at the end of the day, still be tougher for them to be able to use the same approach here to be able to get bail. At the same time, it does mean that at least the court will be looking at the charge sheet and saying, does this allegation make sense? And seeing whether those, the allegations themselves of it being more than just organizing a protest and organizing a chakka jam actually go any further. But yes, it's crucial to remember that you can't, that even before the Supreme Court order saying, oh, this can't be treated as precedent, just these orders would not be enough for all the other accused to be able to get out on bail. It's merely a matter of approach, which can, however, still be used by the courts when looking at bail applications by them. And then, of course, it'll have to be seen whether the same analysis, when it's conducted on the allegations, will lead to the same result.
Thank you, Akash. I think that helps to me. Like, at least I got the basic understanding, like how it will, proceed further. Thank you so much.
Do we have any other questions? Okay, I guess we don't have any more questions. Maybe we can wrap it up now. If there's anything else that one of you would like to say, I mean, Colin, sir, if there's anything you would like to add to your...
I think this was one of the greatest session like I have attended on in recent past, and I feel like this should happen at least once in a quarter, so that we can be updated with the legal aspects of what's going on and how should we react sometimes. This helps us. Thank you so much for arranging this, everyone.
Okay, thank you. I think thank you everyone for joining us today. It was a great discussion. And I hope to have more of these. Thanks.
Thank you.
Thank you.
Recording stopped.
Thank you, Rashmi, and thanks to all of you. And I hope we will be continue that series of the programs on this historic judgment of Delhi High Court, and we will come up with the next week with the same title of the
Recording
program,
in progress.
Public Intellectual. Hope then we will meet you on the next week with some public intellectual, and the topic will be the same. We will discuss the recent High Court judgment on Delhi Royd on UAPA. Thank you very much. Thanks for the joining United Against AIDS System. Thank you. Thanks to all of you.
Thanks, Thanks, Rashmi.